Hello everyone, my name is Joy Malete and welcome to Money Matters. Money Matters is an interactive show that aims to educate our viewers on their consumer rights and provide advice on money-related matters. Do you perhaps have a money-related matter or problem that you would like advice on? Well, do contact us and we may be able to hook you up with some expert advice. On today's show, we are discussing wills and estate planning. I'm sure we've all had to go through the ordeal of losing a loved one, and having to learn that they did not have a proper will in place can somehow complicate matters. Please do share your views and comments with us on Facebook and Twitter using the hashtag #MMOnSID, and don't forget to tag us at the SID Media on YouTube. Joining us today in studio to unpack a little bit more on wills and estate planning is legal experts Hanu Becker and Colette Munsami. Welcome, lady and gentlemen, and it's such a pleasure to have you with us today.
Thank you. It's lovely to be here. Thank you.
Thank you for the privilege.
Thank you so much. I think this topic is quite an interesting one, right? Because we learned that only 14% of South Africans actually do have proper wills in place, which is a shocking statistic. But I think maybe we need to unpack a little bit on what a will is to start off with, and actually maybe explain a bit on estate planning.
Certainly, Joy. A will is a legal document. Mm-hmm. It has to comply with formalities that are not negotiable. Mm-hmm. It is a very important document as it distributes the assets that you've amassed through your whole life. Mm-hmm. It is a document that gives you the opportunity to appoint an executor, mm-hmm. to display your wishes, make known your wishes on burial. It also helps you to appoint beneficiaries. Mm-hmm. It is a very important document. When we do estate planning, mm-hmm. we do it with an eye on a will. We also do it to minimize taxes as far as we can. And therefore, it is very critical as one goes through your life journey. When you are young with our children, your will look a certain way. Okay. When you get married, it will change. When you have children, it will change. If some of the beneficiaries pass away, it will change. Unfortunately, in life today, divorce is a reality. Mm. And even then, and especially then, we should have a relook at our will. So it's a very critical item to discuss, not only as an individual, but as a Christian. Mm-hmm. Estate planning deals with your assets. Yeah. What typically can be described as an asset? Well, it's money. It's your house, your immovable property, your vehicles, your shares. Yeah. Anything that you own that you need to dispose of. And very important, it is critical also to dispose or give directions what to do with your digital assets. Okay. So it's important to give directions. How should your Facebook be closed and wrapped up?
I see. I was about to ask, when we talk digital assets, what exactly do we mean? But I see what you mean. So you have to specifically list that in your will.
Correct. So, you can actually, I'm sorry to interrupt, but when you speak about Facebook and Twitter, it doesn't have to be in the will, but you must have directions to your loved ones with passwords and such.
I see. So what this then leads me to the next question is that, are there different types of wills?
Joy, the will is basically a legal document, but it takes on different formats. Okay. So if you unmarried, for instance, you'll have a single will, just you and your assets. If you get married, it's convenient to join your spouse in the will, whether you're married in or out of community of property. It doesn't have to be a joint will when you're married, but it's convenient. You get one set of witnesses and so on. Then you get a more advanced type of will where you include a trust. This trust, known as a testamentary trust, will only come into being once you die. So while you live, you have full control of your assets, but when you die, it might be that your beneficiaries are unable to deal with the assets. And that would be typically when there's a handicapped beneficiary or a minor.
I see.
So you make provision that a group of experts manage these assets
see.
after your death.
I see.
And then there's something that I would really like to emphasize, and that is the living will.
Uh-huh.
A living will does not deal with assets. A living will is a directive to your physician that today, while I'm full mind and sound memory, I direct that should I get to a stage where I'm unable to decide on my own future, I give permission, providing certain circumstances are present, that the physician might end life support. So in general, this document goes to your physician. And it is important to note, because people are scared that you just give authority to a physician willy-nilly. But there are strict medical protocols in place, and they will give you pain medication. And they'll keep you comfortable. So it's a very, very important document in that it removes that almost impossible plight of having to switch off a loved one's life support.
Machine, yeah. And I think it's quite sensitive, right, to actually discuss this. And you do find, like you've mentioned, so you can have one will and have all these different characteristics listed in that will. And I suppose my question then is, in that one will, say we've got a joint will, we're a couple, we've got a joint will, does that not then complicate the estate planning part of things where it's a joint will? So if we've got a joint will and I pass away and my partner remains, does that not complicate things in an estate planning? It shouldn't.
I don't think that it would, because I think it might just make things easier.
I see.
Because the general flow of estate planning, or when you pass away, what you leave is you care for those close to you first. So you think of your spouse, you'd probably want to leave your estate to him or her first, and then your children, and then further family members or organizations. So having a joint will is actually easier
I see.
in that it shortcuts one of the steps.
Okay.
Yeah.
Okay. Thank you for that. And then for your last will to actually be regarded as valid, what are the key requirements for it to actually stand?
Joy, there are formalities. And I would truly urge our guests not to try this at home.
Okay.
Seek the help of a trained professional.
Yeah.
Please. We work 40 years to get our estate together. And then we thoughtlessly draft a document that does not meet the test of law. Sister Ellen White said, whatever you do, let it stand the test of law.
I see.
Otherwise, you've really wasted your time.
Yeah. Yeah. So we actually do need to make sure that we involve
We
the
do.
right people to actually assist us in drafting this will, and just make sure that also the storage of the will is quite important, right? That the last valid will that is stored and signed off by you is actually the one that you intend to be the one that is used should you pass away. And can the court of law actually set aside a valid will?
Joy,
And under what
it will not
circumstances?
set aside a valid will.
Okay.
Once it's valid, it's valid. A high court, does have the capacity to set aside a will. If there are signs of trickery or dishonesty,
I see.
chief amongst them being undue influence.
I can imagine. And say if say for example, I didn't update my will and I had a child. It's still a valid will, but then I had a child afterwards that I didn't update the will. Can then the court make sure that that child is catered for in that will that does not include the name of that child?
Joy, our law of interstate succession and testate succession has its roots in ancient Roman law. And therefore, it is a process of common sense and family needs over many years.
Hanu, sorry, I think we need to take a break. Can we just hold that thought, and then when we come back, then we just sort of close it out? Okay, we'll just take a short break, and when we come back, we'll just continue our discussion with Hanu Becker. Please do stay tuned, and don't forget to interact with us on social media using the hashtag MM on SID on both Twitter and Facebook. See you shortly.
All of these and more on SID Media TV.
Welcome back to Money Matters. If you've just joined us, we are talking wills and estate planning with Mr. Hanu Becker and Ms. Colette Munsami. Please don't forget that you're also part of this conversation, so please do share your views and comments with us on Facebook and Twitter using the hashtag MMOnSID. And before the ad break, we were just having a very insightful conversation with Mr. Hanu Becker. But before that, please do use the link that is appearing right now on your screen just to share your views and comments with us. Mr. Hanu, we were still chatting about where there's a beneficiary, right, that you have not included in your will.
Yes.
What happens then? Because this is a valid will, one, but there's this child that I've forgotten to include in my will or update my will with their details. What happens then?
As I said, our law is rooted in Roman, Dutch, English law, and it's based on common sense. What were the needs through the ages? So when you have a child that you've omitted, either negligently or on purpose, that child does have a claim as a creditor, not as an heir, but he has a legal claim against your estate for maintenance.
Wow.
The same, very fortunately, for a surviving spouse. If a husband and wife is not on good footing and he leaves her out of his will, just ignores her as a beneficiary, she has a claim against the estate in terms of a different act as a creditor, which means the minor child or the surviving spouse actually ranks above normal heirs because they have a legitimate claim for maintenance.
Sure. That's quite hectic. I think the easiest then is just to make sure as a parent, you update your will.
Correct.
Or even as a person, whether you've got, just make sure that your will is always up to date.
Correct.
That's quite interesting. And perhaps maybe just touching on estate planning, Colette, when and where must a deceased estate be reported?
So Joy, if you have this will and it's updated, and it's good practice to probably update it yearly. Even if things haven't changed too much, just look at it again, something. Maybe you've changed a job and not family. So if you've looked at your will at least annually, you would know where that will stands and you'd know where your original will is.
I see.
And so my advice is to let someone in your family know that you have a will. I know it's a top secret and family don't need to know the content of your will, but let them know that you have a will and that it's with whichever attorney or at the bank, wherever, so that your family members know where to go when you pass away.
I see. Do banks still keep wills?
Yes, they do.
They still do.
Yeah,
okay.
they do.
Okay. And then who is responsible for reporting a deceased estate?
So once a family member, unfortunately, someone passes away, the closest family member or child will probably notify this nominated executor, and that's why they should know where it is. So they will contact the attorney and ask them to start the process. The attorney will probably meet with the family members, children, surviving spouse, whoever it might be, and ask them a few questions. There'll be some documents you'll need to bring along, the death certificate and ID and so forth. And that's when the process will start with the attorney at his offices.
So the executor, do you stipulate this in the will, who the executor is, or is this someone who is appointed, say, by the court of law?
I think that's one of the benefits of having a will, is that you get a chance to nominate an executor.
I see.
And if you don't, that's just one of the things, without having a will, you don't have an executor, and then it's run with family members. And like Hanu said, please don't try this at home.
Don't try this. Get the right people to actually be involved. It's quite sensitive. And I think having to deal with losing someone, and again, the burden of having to deal with the distribution or the execution of their estate can be quite tiresome, especially to the people left behind when they're still mourning. They're in a state of mourning and they still have to deal with all these complexities.
So Joy, it's very important that you establish a relationship with your executor.
Yeah.
it's, as you said, it's an intimate affair. The person knows your family woes. They know the challenges. They know your assets or lack thereof. So this is a relationship you build up over many years. As for the person who must report the estate, it is actually an offense if you are in possession of a will not to report it to the Master of the High Court.
Okay.
So please don't think you can hide wills. It is an offense.
I see. Wow, that's quite insightful. And I suppose this is a Money Matters show, and we are always interested in what the cost implications are, right? And so what are the cost implications of actually, what do you call this, of executing a deceased estate? What are the cost implications there?
So in terms of the Administration of Estates Act, there's a few administrative costs as well as the executor's fee that is liable. The executor's fee is 3.5% of the gross value of the assets. And then there's administrative costs, which are bank charges, a master's fee that we have to pay, you have to advertise the estate. So that also adds up, but it never exceeds about 5,000 or 6,000 rand.
But I mean, if say the value of the assets that you're leaving behind are worth 4 million, I'm just hypothetically speaking, 3.5% can be quite hefty, especially for people left behind to try and cough out.
It's 140,000 rand on 4 million. So it's a lot of money.
That was a quick maths calculation in your head, Anu.
And I think that is one of the tools that you have to use in estate planning. Is there enough cash in your estate when you pass away?
I see.
Did you make provision for your minor children, for education? Is there provision made for the surviving spouse? Often, one of the parties are the breadwinners. And if they fall away, the income is gone.
That's true.
And one should also make provision for the proceeds of policies. Because, you have a person who's not necessarily an adept in finances. And that person has policy payout of 10 million. You should guide
the use
and maybe set up a trust.
Yeah.
So you must provide now for what happens after your death. So that's the reason for estate planning, is looking at adequate cash, looking at assets for the survivors, the dependents, and seeing what can be done in minimizing your tax, income tax, capital gains tax, estate duty.
So many taxes.
To minimize your risk exposure. So that's really
so many taxes. You get taxed when you live, when you're alive, you get taxed when you die. So many taxes.
Joy, if I could just add on to what Anu's saying, is that one of the reasons why you should have this cash planning for your estate is a lot of the assets at death are fixed. So it's not a cash income that you can raise on, but the expenses are still there. So it would be good to financially plan for that as well.
Hanu did say, do not try this at home. Please don't try this at home and get some expert advice. Well, that's quite interesting then. And so then maybe this leads me to my last question around guardian funds. And how does it work?
Joy, there are two avenues in caring for minor children. The one is the Guardians Fund. It is a fund of the Master of the High Court that provides for safe investment opportunities for minors and mentally incapacitated persons. However, it is a state office and it is subject to certain challenges. Where there's enough money, million or more, I would suggest getting a trust.
Okay.
And remember, a trust is not like a shelf company. You cannot get a trust off a shelf. It is a crafted document. It's part of your will, but it's a crafted document. And it makes provision for any eventualities.
I see.
And it gives it gives you the opportunity of appointing a legal person, a family member, a financial person like yourself, to properly manage the assets on behalf of the beneficiaries. It's a very, very important job. And
Hanu, sorry. I want you to hold that thought because I don't want us to rob our viewers on this particular element. And I think let's maybe pick that up after the break. And we will be going for a quick short break and we'll be back right after this. Don't forget that you're also part of this conversation. Continue engaging with us on social media, Facebook and Twitter using the hashtag #MMOnSID. We'll be right back. Welcome back, and this is Money Matters. And if you have just joined us, well, I think you've missed out on quite a bit. But yeah, we are still continuing with our discussion on wills and estate planning. And I think we've had quite an insightful discussion, right, on the importance of having a will in place and just making sure that you have all your ducks in a row when it comes to estate planning. We've been learning quite a lot from Hanu and Colette about this topic. And I think maybe we just need to pick it up there, Hanu. I think before the break, we were discussing a guardian's fund and the importance of it. And I think sorry for abruptly disturbing you there. But can you just maybe pick up from where we left off?
Certainly. So the Guardian's Fund is an established office at the various masters' offices. Mm-hmm. When we think of a trust for beneficiaries, it can encompass any beneficiary and even the church as a beneficiary of your trust. But you can also think of the Lord's work in your will.
I see.
So the benefits of the Guardian's Fund is it costs nothing.
Okay.
And you earn compounded interest. But it's a slow and a cumbersome process. And when there's enough money, I would really suggest getting a trust. And there you can flesh out and tease out who your beneficiaries are, at what percentages. Is there a reason that their beneficiary status might be suspended in future? Do we want to maybe not have a beneficiary get any capital, but only income? So there's a myriad things that you can craft in a trust that is really of benefit to the testator.
I see. And where you've appointed, say, a guardian in the trust, you've appointed a guardian, do the trustees of the trust, right, make sure that the guardian does not request more than what they require to actually support the child who is a beneficiary?
One of the provisions of the Trust Property Control Act is that there should be at least 3 trustees. And so I think that safeguards a guardian from just doing what they want with the money, where there's be 2 other trustees who will also manage the funds in a trust.
I see. Okay, that's quite interesting. And then, Hanu, are there any, last advice that you can perhaps give our viewers around the importance of having a will? And I think we've stated this throughout the show, and we really clearly understand why we have to have it in place. But anything in particular that you perhaps want to highlight that people need to keep in mind should they forget everything that we've discussed today?
Certainly. The first thing is, don't try this at home.
Don't try this at home.
Get a professional person to assist you. Remember God's work when you do estate planning. It is critical for a steward in the church not to necessarily bring in to your will a long line of relatives who might have left the faith. My advice is never for a parent to disinherit a child because they're not in the church.
I see.
There are ways. Please don't do it. It's very hurtful. And I think what is very important, that's often neglected when a parent, especially a parent, does estate planning, is that the name of the guardian and the characteristics and the qualities of this person or people must be noted. And discuss it with your spouse. And discuss it with your intended guardian. Don't let it be a surprise to him or her. And also, consider whether the guardian has financial resources to accommodate your children. I think the benefit of a will is really it's a non-negotiable for a Christian. It is in line with the Bible. It's in line with our church policy. It's just good citizenship to have a will that stands the test of time.
Any final words, thoughts that you perhaps want to leave with our viewers at home?
If I can leave one thing, Sister Ellen White says that you will not cut your life short by one day by doing a will. So please go and do a will. It doesn't mean you're going to die soon.
It doesn't mean you're going to die soon. It's inevitable.
My parting words would definitely be, it's almost more dangerous to have an outdated will than no will at all. So please, just like Colette said, revisit it. You don't have to change it annually, but just revisit it, just look at it, speak with the person as nominated executor, just see to it that things are current.
Wow, it's been quite an insightful conversation, and thank you once again for sharing your views and for sharing your insights with us and for helping us unpack this very difficult topic. And I think they say two things are certain, and that is taxes and death. So we just need to make sure that we plan properly for these things, these eventualities that we do know are essentially going to happen at some point in time. It was such a pleasure to have you both with us.
Thank you. Thank you very much.
Thank you, Joy.
Well, we have come to the end of today's show. It's been power-packed, it's been insightful, and I'm sure that you've learned quite a lot from this discussion. Please continue to share your views and comments with us on Facebook and Twitter. Just let us know what your thoughts are. Do you have a will in place? You know, what are some of the complexities that you've had to experience with losing a loved one who had no will in place? Please do continue engaging with us. We'll see you online shortly, but if you don't have, if you can't join us online rather, please do tune in again next week. Same place, same time, same place rather, right here on Money Matters. And from me, Joy Malete, and the rest of the Money Matters team, it's goodbye and God bless.